All right, welcome everyone, and thanks for joining Katie Douglas and me, Ryan Johnson, for today's webinar on structuring and negotiating a healthcare transaction. Before we start the webinar, a couple of quick housekeeping items. First, if you have any questions, please enter them in the chat box in the lower right corner of your screen. Time permitting, we'll try to answer your questions at the end of the webinar. If we run out of time or otherwise miss your question, we'll try to contact you offline to answer those questions. Our next webinar will be on February 10th, and it will cover pricing with David Glazer. Please do fill out the surveys at the end of the webinar. They help us improve the webinars and help us select topics for future webinars. If you do have to leave early today, please know that the slides with audio will be available via SlideShare. And finally, Powerball tickets are still available. All right, moving on. So, as I'm sure all of you know, healthcare is a heavily regulated industry, with laws and regulations covering virtually every aspect of how services are delivered and reimbursed. Failure to comply with these laws can result in significant fines, criminal penalties, and professional discipline. It's obviously very important that healthcare transactions be structured to comply with applicable laws and regulations and manage risks for the parties. In today's presentation, we're going to provide an overview of some common healthcare transactions and summarize the key regulatory considerations when structuring these transactions. At the end of the presentation, we're going to review a typical physician-hospital joint venture to demonstrate how these laws and regulations come into play when structuring one of these transactions. All right, so joint ventures. Joint ventures are very common in the healthcare industry, often involving physician groups and hospitals. A joint venture is an enterprise in which two or more parties integrate their operations. They have joint control over the enterprise to the extent allowed by applicable law, including antitrust laws, which we'll talk about during today's webinar. All the joint venture participants often make substantial contributions in terms of cash, in-kind contributions, or through various service agreements. Importantly, joint ventures are for a limited and specific purpose that you need to define very carefully in the governing documents. When properly structured, joint ventures allow competitors to collaborate without violating antitrust laws. Sometimes competitors find that cooperating and making love not war is the right decision for financial, political, and strategic reasons. So the types of joint ventures include contractual joint ventures. Two competitors, hospitals and physician groups, get together and agree to jointly provide certain services or products through contractual arrangements. Examples include leasing arrangements, management service agreements, professional service agreements, but many refer to these types of arrangements as contractual joint ventures. Joint ventures can also be structured as through joint ownership of a new entity that will provide the services or the products of the joint venture. We find that typically in the healthcare space, what you see are hybrid joint entities, where you have the members of the joint venture jointly owning an entity with various contractual arrangements between the JV and its owners. For example, a hospital might provide payer contracting services to the joint venture that it partly owns, whereas the physician groups might provide professional services and management services pursuant to various agreements, and those physicians will also be owners of the joint venture. Another common transaction you've seen in the healthcare industry for many years through consolidation or acquisitions. There are three primary ways to structure the acquisition of a company: the purchase of assets, the purchase of stock, or the merger of the companies. Now, in an asset purchase transaction, the buyer only purchases specified assets of the business and only assumes specified liabilities, if any. When purchasing shares, the buyer purchases ownership of the entire company, including all of its assets and liabilities, including known and unknown liabilities. In a merger, all the target company's assets and liabilities are acquired by the acquiring company. Now, in a heavily regulated world like of healthcare, with substantial penalties for noncompliance with various laws like the Federal Anti-Kickback Statute, the Stark Law, and the False Claims Act, many buyers prefer asset transactions so they can avoid assuming responsibility for pre-closing violations of healthcare laws and regulations. Again, the main advantage of an asset purchase transaction is that it allows the buyer to structure a deal to purchase only those assets it wants to purchase and assume only those liabilities it wants to assume. The disadvantages of asset deals include often a higher requirement and a higher burden of getting third-party consents to transfer certain assets, such as lease agreements. The transaction could be subject to double taxation if the target is a C corporation. Note that this disadvantage goes away if the target is an S corporation or other entity with pass-through taxation. The other disadvantage is the challenge of defining and valuing the assets the buyer wants to purchase. But oftentimes, buyers overcome these challenges and do decide to structure an acquisition via the purchase of assets, again, to avoid assuming various liabilities. The main advantage of a stock deal is that it's relatively inexpensive and easy to execute. There's often only one level of taxation at the shareholder level, and depending on the nature of the transaction, percent of ownership sold, for example, and the terms of various contracts, not as many third-party consents may be required. Again, the obvious downside to a stock transaction is that the buyer assumes responsibility for all liabilities, known and unknown, and assets of the target, although risk and responsibility can be allocated by the parties via reps and warranties and post-closing and other provisions. Now, in any acquisition, there will be consideration that's often paid, be in the form of cash, earnouts, or equity. The consideration always has to be structured to comply with applicable healthcare laws and regulations, including the anti-kickback prohibition and the Stark Law, which Kate will be discussing later in this webinar.
Okay, thanks, Ryan. So I just want to mention here that there are, many other types of healthcare transactions outside of joint ventures and acquisitions that are kind of more everyday transactions that could have regulatory implications if you're dealing in the healthcare space. Slightly related to, governing documents and joint ventures, which we'll talk about a little later, you'll need to consider the regulatory impact that could be had on shareholder agreements among shareholders, for example, in a physician group. For example, the Stark Law, which again we'll discuss in a little bit, has very specific restrictions on how profits from certain healthcare services can be shared among physician owners. Stock redemption or buy-sell agreements could also be affected by the Stark Law and other regulations, and even compensation agreements, specifically deferred compensation agreements, could be restricted by 409A of the Internal Revenue Code, which imposes limits and conditions on how deferred compensation can be paid out to shareholders who have left the business, and when those payments can be made. So the bottom line is there's a myriad of healthcare transactions that require parties to consider applicable regulatory restrictions while still trying to achieve their business objectives. So something we've seen more and more of lately is that the healthcare industry has new players in it every day. In particular, private equity, venture funds are getting into the game. What we're seeing here is that the current regulatory framework isn't necessarily made for private equity investment in healthcare services. As we'll discuss later, this creates the need to come up with some more complex transaction structures, such as the friendly PC management company model. This is a structure that wouldn't have otherwise been required back in the days when the only players were, hospitals, physician groups, and, other providers who were actually delivering the care. Also, pricing and valuation mechanisms that are common in other areas of M&A, such as earnouts, need to be carefully structured if you're dealing in the world of healthcare services, especially if the services or items are reimbursed by federal health care programs. And other types of agreements that are kind of more common that we're not going to get into in great detail today, but that can have regulatory implications, management services agreements between healthcare providers and, business corporations or, laypersons, or even between, hospitals and physician groups who have lots of regulatory implications. Professional services agreements, also software licensing agreements. We're seeing more of this as healthcare IT is becoming hotter and hotter, that you'll need to structure those types of arrangements in a way that take into account the regulations at play, because I think a lot of times you'll have kind of competing interests where if you have the IT people who are kind of focused less on the healthcare ramifications, and so that's why it's important to be aware of the regulatory landscape when structuring these types of agreements. Okay, so there is no one way to do a healthcare transaction, and there's also every healthcare transaction is going to be a little bit different, but there are some common elements that are usually present in all healthcare transactions. An initial step that's common is the letter of intent, or the LOI, and a nondisclosure agreement. The initial question when dealing with an LOI is, will it be binding or non-binding? The most common version is an LOI that has both binding and non-binding provisions. The key here is to delineate clearly which provisions will be binding and which provisions will not be. For example, you'll usually want to include binding confidentiality provisions that apply to the discussions and even the identity of the parties that are involved in those discussions. It's important to note that even if the language of a letter of intent indicates that it's non-binding, if you spend a significant amount of time and resources negotiating very specific points, then I think that could raise the question of whether the letter truly is binding on the parties. And courts have looked at this issue before and have looked at supposed non-binding letters of intent, and they found that despite the use of the term non-binding, the provisions were in fact binding on the parties. So the key here is to make sure that the parties are on the same page with respect to what provisions are binding and what is still left open to negotiation. The biggest benefit to doing a letter of intent is that it gets everyone on the same page with respect to the expectations of the transaction rather quickly. It can help identify what the key issues will be and, perhaps more importantly, what the deal breakers will be. Also, a letter of intent is a good idea for regulatory reasons. As Ryan's going to discuss later, a letter of intent can be a sign that the parties are one venture working toward a common goal, rather than competitors simply engaging in anti-competitive behavior. If the letter of intent contains a binding no-shop or an exclusive dealings provision, another big benefit is that it can give both parties comfort that, at least for a limited period of time that's set forth in the LOI, that the other party isn't going to be shopping the idea out to find a better partner while the other party is investing resources and time toward getting the deal done. An LOI can also serve as a placeholder while valuing in-kind contributions of each party. It makes sure that both parties remain committed to the deal while some of the other issues are being sorted out. One of the biggest negatives that I hear from clients to a letter of intent is that it might mean additional expense negotiating a document that isn't, entirely binding. This actually can result in another negative is to avoid those expenses. Parties will often leave lawyers out of this step in the process. Legal counsel does play an important role in structuring healthcare transactions and joint ventures. So the risk you run with leaving lawyers out of the deal at this stage is that you spend time and money negotiating a transaction that might not be consistent with the regulatory landscape. Or, even regulatory compliance aside, one of the parties may have negotiated key terms in a deal that if the party's lawyer had been present could have turned out to be more beneficial for that party. So even though it may mean, additional expense, keeping lawyers involved in the LOI stage is usually advisable. One downfall of the LOI is that the parties are negotiating before they've done a full diligence review of what the other party is bringing to the table. So you may find yourself having negotiated a term that once you're further down the diligence road might not be appropriate anymore. This is why we always include language clarifying that certain terms are subject to further diligence, which gives the parties flexibility to change the terms down the road. So all in all, I think letters of intent are a good idea, but it's important to be aware of some of those key issues when structuring them. So, the next step is often, once you've negotiated the LOI, is you engage in the diligence process. First, if the LOI does not contain a confidentiality provision, you'll want to make sure that you have a separate confidentiality agreement or non-disclosure agreement. This is important, especially if you have, if you're doing a healthcare IT deal and you have intellectual property that you want to protect. You want to be very careful about at what point the details of that intellectual property are disclosed. And it's kind of a balancing act here because, as a seller, you don't want to necessarily be showing all your cards when it comes to your intellectual property if you don't know that a deal is going to happen. But if you're a buyer, you want to know what the seller has and get a good sense of what you would be buying and how to value that. So that's why a carefully drafted confidentiality agreement is key in this situation. Also on the diligence front, it's important, when you're dealing with a healthcare transaction, even arrangements that might not seem related to healthcare at all, may have regulatory implications because you're in the healthcare space. So, for example, office leases, if, let's say, for example, you have a hospital that has an office lease with a physician group in town, while you should be reviewing that from a real estate perspective, you also want to make sure that the lease complies with all of the elements to the Stark exception for leases. So, on the topic of definitive agreements, many parties will focus on the purchase agreement if you're doing an acquisition. But, oftentimes there's more than one agreement that plays a role. It's first important to understand the overall purposes of these agreements. The purpose is to define what the joint venture, in the case of a joint venture, define what that joint venture is going to do, what it covers, and perhaps more importantly, what it doesn't cover. You want to be very careful in crafting the purpose of a joint venture to make sure that the parties' expectations are aligned with what they'll be partnering to do together. If drafted too broadly, then it might unintentionally capture current or unrelated business activities of one of the parties. On the flip side, if drafted too narrowly, then that can hamstring the board or management in expanding the business. So an example of this would be, the operating agreement for a joint venture entity will often have provisions that say that a board can make management decisions, but that certain key decisions require the approval of the members or the shareholders. Often one of these key decisions is to change or expand the core business functions of the entity. If those functions are defined very narrowly, then you can find yourself in the position of needing to seek member approval more often than you'd like. We also often see separate agreements to cover affiliate relationships between one of the parties and the joint venture. For example, as Ryan mentioned earlier, one of the parties might provide management services to the entity, or like a physician group could be providing professional staff to the entity. And so a key question in these agreements is whether and to what extent you want these affiliate agreements to contain cross-termination provisions. Will a breach or termination of one agreement result in the termination from the joint venture? Another key element of, in the case of a joint venture agreements, is what will happen in the event of a breach. Will there be financial penalties? Will there be an unwind provision? Or will the non-breaching party have the ability to buy out the breaching party and continue the joint venture on its own, without the other partners? If there is a buyout, what will the purchase price be? Should it be reduced? Should it be a reduced buyout to penalize the breaching party? Whenever you impose any sort of penalties, you'll want to make sure that those penalties aren't really proxies for, punishing a party for failure to send referrals to the joint venture, as we will discuss later.
All right. Key business issues. The key business issues you see outside the healthcare industry are obviously at play when you're doing healthcare transactions. The scope of the transaction. If it's a joint venture, what's the geography covered by the joint venture? What services, what items will be provided by the joint venture? Ownership and control. Who's on the board? Who gets to appoint board members? How are they removed? are the reserve powers who approve certain matters that certain members hold. All these issues come up in healthcare transactions, but the healthcare players have to consider regulatory issues when structuring these provisions. We'll talk about selection of investors. How do you select investors for a healthcare transaction? How do they buy in? How are they offered their equity? How is it priced? These issues implicate the anti-kickback statute, the Stark Law, tax exemption issues. And we're going to cover these issues from the perspective of these various healthcare issues going forward.
Okay, so clients are often surprised to learn, surprised to learn about, just how many regulatory implications a healthcare transaction can have. We'll be talking about anti-kickback laws, both at the state and federal level, self-referral prohibitions, that's the Stark Law, and there are also state versions of the Stark Law, antitrust, fee-splitting regulations, corporate practice of medicine issues, tax exemption, and then also FDA issues. So, we keep saying this over and over again, but really you can't just look at one set of laws whenever you're in the healthcare space because, even if one might not apply, you'll have to think about another type of regulation. Okay, so the anti-kickback statute. I like to think of the anti-kickback statute as kind of the mother of all health regulations just because it seems to play such a role in almost every deal. The anti-kickback statute makes it illegal to offer, solicit, make, or receive any remuneration intended to influence or reward referrals of federal healthcare program business at the federal level. Regulators and courts will use what's known as the one-purpose test when analyzing a joint venture or an acquisition or other sort of healthcare arrangement between parties, meaning that if even one purpose of the arrangement is to line the pockets of your highest referral sources, then we're going to have a problem. The statute does have a series of safe harbors that offer protection from anti-kickback scrutiny, and depending on the type of transaction, you may be able to fit into or get close to fitting into one of the safe harbors. The safe harbors usually have several elements that aren't always realistic to meet, however, but the good news is that you don't have to satisfy a safe harbor to be in a compliant venture. However, the closer you can get to meeting a safe harbor, the general thought is that the transaction might be less risky and the more comfortable some parties may be in moving forward with the transaction at hand. So the sample of joint venture that we're going to discuss a bit later is a hospital and physician-owned ASC. So I'll briefly mention the ASC safe harbor. There are 4 categories depending on what type of physician ownership there is. And the one that's relevant for our purposes today is the physician-hospital-owned joint venture. They all have similar requirements that vary slightly among the type of surgery center, and we'll discuss those elements in more detail later. A very important note, there are also state law variations of the anti-kickback statute. These are known as mini anti-kickback statutes, or I've heard people call them baby anti-kickback statutes. They may be identical to the federal version. They may have their own safe harbors. They may have no safe harbors or exceptions at all. And parties are often surprised to learn that if they're dealing in an industry that has no Medicare or Medicaid reimbursement, let's say it's purely cosmetic services, they still might have issues under a state anti-kickback statute if that state version applies to all healthcare services and items provided in the state. Sometimes a mini anti-kickback statute would apply to any services or items reimbursed by any insurance, or they might apply to any services or items regardless of insurance coverage. The anti-kickback statute could also have an impact on the ability of parties to use an earn-out as a portion of the purchase price. I think this is a very, using earn-outs is a very common way to structure the price in, an acquisition, because it can give the buyer more certainty in kind of the actual value of the business and what it's really, the value of what it's buying. So a sample earn-out structure in a healthcare deal might say, if post-closing revenues of the business are X, then the seller will get an additional post-closing payment, 12 months down the road. So the reason that an earn-out could trip up the anti-kickback statute, either on a federal or state level, is that a regulator could argue that if the seller is still in a position to refer services to the business following the closing, then that post-closing payment is really a payment for referrals to what is now the buyer's business. So you want to be very careful when structuring the payment of the purchase price to make sure you aren't running afoul of any state or federal anti-kickback statutes. So moving on from the anti-kickback statute, the Stark Law could also be a regulatory hurdle that you need to cross whenever you're structuring a joint venture or an acquisition in the healthcare space. Stark is a federal law. It's a civil law. It basically, prohibits a physician from making referrals of designated health services, or DHS, to an entity if the physician has a financial relationship with that entity, unless that relation satisfies one of many exceptions that are in the statutes and regulations. So some exceptions are, there are exceptions for personal service agreements, for real estate leases, for equipment leases, and ownership arrangements. Even though every exception is a little different, there are common themes or common requirements in all the exceptions. They're going to require fair market value compensation. That compensation is going to need to be set in advance. Usually there's the compensation can't vary based on the volume or value of referrals coming from the physician. If there's an agreement, it's going to be, it's going to need to be an agreement in writing. Usually there's a requirement that there be a term for at least 1 year. So there are lots of exceptions with very specific requirements. And failure to meet an exception is an automatic violation of the Stark Law, unlike the anti-kickback statute, which will look to the intent of the parties, and that if you don't satisfy a safe harbor, you're not automatically in violation. One important thing to note about the Stark Law is that it only applies to DHS, and DHS is a very specific list of services. Examples are lab services, hospital services, and imaging. So it might not always apply depending on the services or items that are at play in the specific transaction you're dealing with. For example, usually it doesn't apply in the ASC context because ASC services aren't one of the listed DHS. An important caveat, though, is if the ASC provides other DHS, such as imaging services, then you'll need to consider Stark and make sure you structure your deal to satisfy an applicable exception. And as I mentioned earlier, the Stark Law is also relevant to diligence as well. If you run into, especially if you're doing, a stock deal or a merger, if you find a lease that, violates or doesn't meet the Stark lease exception, you'll have to consider what to do about that. There is, well, I guess it's not really that recent anymore, but there's a specific now disclosure protocol for Stark violations, and oftentimes parties will engage counsel to see whether it makes sense to do that, and kind of usually to do that before closing and as a condition to closing. All right, Ryan is going to talk about antitrust.
All right. So there are many antitrust issues associated with healthcare transactions, their acquisitions or joint ventures. The main goal of the antitrust laws is to protect competition in the market, not competitors, which in theory maximizes utility for consumers through lower prices, higher quality, and more innovation. There can be fines, penalties, and for violations of the antitrust laws. Private parties can bring causes of action for damages, including treble damages and injunctive relief. It's important that transactions, acquisitions, joint ventures be structured to comply with state and federal antitrust laws. Of course, all relevant antitrust laws, including Hart-Scott-Rodino, and any required HSR filings need to be addressed when structuring acquisitions, joint ventures, and other transactions. But today we're going to focus our time on Section 1 of the Sherman Act. So the Sherman Act, Section 1, prohibits contracts, combinations, or conspiracies in restraint of trade. Now, there are certain per se violations of the Sherman Act. Price fixing agreements between competitors, allocation of territories or customers, customer or other non-price restraints, group boycotts, certain concerted refusals to deal, etc., can all be found to be per se violations of Section 1 of the Sherman Act. Other arrangements between competitors are analyzed under the rule of reason under the Sherman Act. The questions being, do the challenged arrangements promote or suppress competition in the market? And do the challenged arrangements unreasonably restrain trade? Importantly, a violation of Section 1 of the Sherman Act requires an agreement between two or more economic entities which has an anti-competitive purpose. In healthcare joint ventures, hospitals and physician groups often remain competitors in multiple service lines unrelated to the joint venture. And sometimes they remain competitors in service lines covered by the joint venture. In joint ventures like these, there are many antitrust issues to consider, including whether any of the agreements between the joint venture and one of its members violates Section 1 of the Sherman Act. For example, if the joint venture and one or more of its members agree on pricing, for example, by jointly negotiating payer agreements or geographies in which they will or will not compete, these agreements could be found to be per se violations of Section 1 of the Sherman Act if the members are considered separate legal entities. Now again, you have to have two separate economic entities. What about parent-subsidiary relationships? Is a parent and a subsidiary, are they deemed to be separate economic entities for purposes of Section 1 of the Sherman Act? If they're deemed to be one, they're legally incapable of conspiring with one another. If they're deemed to be separate legal entities, they can enter into unlawful arrangements under Section 1 of the Sherman Act. What about joint ventures? Fortunately, the Supreme Court, in a case called Copperwell Corp. Versus the Independent Tube Corp., addressed some of these issues. This case involves a parent and wholly owned subsidiary, and the Supreme Court found that these entities were incapable of conspiring with one another because they were deemed to be one economic entity. The Supreme Court looked at the fact that they had a unity of economic interest. The parent and subsidiary were totally aligned. The profits or losses of the subsidiary, its economic performance and goals was directly related to the goals and objectives of the parent. The corporate actions of the parent and subsidiary were guided by a single corporate consciousness, meaning that essentially the parent can control the acts of the subsidiary. Now, lower courts have debated the meaning of this case for over 25 years, trying to establish rules for how Copperwell applies where a corporation owns less than 100% of the equity of an affiliated entity, which by definition is always the case in physician-hospital joint ventures. Now, the Copperwell requirements for joint ventures are not crystal clear. If you look at the case law that's out there, the courts focus on a legal control test. The question being, could a parent exert full control over the subsidiary joint venture if it failed to act in the parent's or one member's best interests? Now, the courts apply a unity of interest test as well, which look at a preponderance of multiple factors. If you look at the case law, a couple of questions sort of rise to the top. The questions the court will look at include, does the joint venture, is it required to act in a manner consistent with a member's goals and objectives? For example, with a hospital-physician joint venture, is the joint venture required to operate in a manner consistent with the hospital's tax-exempt status? Another question, if the member does not have the right to appoint a majority of the joint venture's board, does that member have the authority to approve and remove the other joint venture members' board appointees? Other questions, does the joint venture, is it allowed to compete with its owners in a relevant market? If it's allowed to compete, that calls into question whether there's a single economic interest between the joint venture and its members. Other questions, does the member have the right to remove any fundamental changes to the joint venture's business? If not, again, that calls into question whether there's a single economic actor. There are many other questions that courts have looked at when trying to answer the question of whether a joint venture and one of its members should be deemed to be a single legal actor with a unity of interest. But again, the takeaway is there's no clear answer to that in the case law. Civil majority ownership of an entity is probably insufficient, since members and shareholders through control or voting agreements can can change the default governance and control rules. If too much control is granted to a minority owner, the joint venture arrangement may not be classified as a single entity under Copperweld, exposing the joint venture to antitrust liability under the Sherman Act. The legal control is a critically important factor, not just simple majority ownership. It's important that parties consult with counsel to structure the arrangement to make sure that control and economic interests are structured to avoid issues under Section 1 of the Sherman Act. Now, if the Copperweld test is satisfied, that doesn't mean you're free under the antitrust laws, including under the Sherman Act. If the Copperweld test is satisfied, you still have to look at Section 2, and that prohibits conduct that creates, sustains, or threatens monopolization. That's more difficult to prove than Section 1 violations, very fact-intensive. What's the relevant market in terms of geography, the service line. But when structuring these, again, pay attention to Copperweld and make sure control is set up appropriately.
Okay, so moving on to fee splitting. So fee splitting statutes or regulations are found in most states. What they do is they prohibit the sharing of fees received for healthcare services or items. Fee splitting statutes are often found in the professional licensing statutes or regs. They can sometimes also be found in a state's general healthcare laws. So, for example, some states may have fee splitting prohibitions that apply only to certain professionals, just optometrists or just physicians or dentists, while other states will have a general prohibition against any healthcare provider sharing fees for any healthcare services or items delivered by that provider. The policy behind fee splitting prohibitions is the perceived danger of allowing professionals to share their income with non-professionals. The thought is that a physician or other healthcare professional's decision-making will be skewed due to financial incentives. Okay, so why do we care about fee splitting prohibitions? Well, one example is if the parties will have a management arrangement following the transaction where the management company provides all the administrative and non-clinical business support services to a healthcare practice. If you're operating in a state with a fee splitting prohibition, you'll likely be limited in your ability to have the management fee be based on a percentage of that practice's revenue or income. Unless the state has an exception for such arrangements, just as the state fee splitting statutes vary, so do their exceptions. So sometimes you'll find exceptions that, if the fee is based on the fair market value or reflects the fair market value of the services that are provided, then they'll be permissible. But it varies state to state, and it also varies depending on the professionals involved. Similarly, if you had some sort of earn-out or post-closing consideration that's structured as a percentage of post-closing revenues, that could also raise issues under a state fee-splitting statute. So the key is just to consider whether or not fee-splitting statutes apply based on the type of services that are being provided and the professionals involved. So another set of laws and regulations that you'll want to be familiar with if you're engaging in a transaction where a business corporation wants to have an interest in a healthcare business is the corporate practice of medicine doctrine. The corporate practice of medicine doctrine prohibits business corporations that are owned by laypersons from employing physicians or other professionals or owning medical practices. So the policy behind this doctrine is that business corporations would be too focused on the bottom line, which would cloud their ability to deliver the best patient care. So many scholars have challenged these corporate practice prohibitions and say that the policy behind them, is inaccurate. There has been lobbying by some, heavy hitters in the industry to repeal state corporate practice of medicine doctrines. On the other hand, physicians and other professionals might not want to see their state's corporate practice doctrine repealed, since that would open the door to more competition from larger companies who may be able to benefit from larger economies of scale, and would make it more difficult to compete with those companies. So also just a side note, I say corporate practice of medicine, but there are also prohibitions against corporate practice of dentistry, nursing, other professions depending on the state. So it's a creature of state statute, and so it will vary on whether or not it exists in your specific state, as well as what professions it applies to. So if you find yourself in a state that has a corporate practice prohibition, you will need to structure your transaction to comply with the law. The most common way to achieve this is to set up what's known as a friendly professional corporation and management company model. So I have a little picture of what that model looks like. So under the friendly PC model, a professional corporation, or it could be a professional limited liability company if your state allows that type of form. That PC is owned solely by professionals. The PC then enters into an administrative services agreement under which the management company, which is the business corporation or business limited liability company, provides all of the non-clinical administrative services for the operation of the healthcare practice. The agreement needs to be drafted very carefully to avoid any overreaching by the management company in anything that deals with clinical decision making. States will vary on how strict they are when reviewing these types of agreements. Some states may even require management companies to register with the applicable licensing board to keep an eye on those management companies. Sometimes you may be required to produce the management agreement so the regulatory boards, the licensing board can review the certain functions that the management company is providing to make sure that it's not engaging in the unauthorized practice of medicine or dentistry. So here are some common elements of management or administrative services agreement. They're typically long-term and not an agreement that's easily terminated at will. If you're the management company, the reasoning behind this is because you want to protect your investment in the brand that you've built. Oftentimes, the management agreement will contain some sort of some provisions where the management company will license certain intellectual property, such as the entity name or trademarks. There'll be a license to the PC for the PC's use during the term of the management agreement. And then if the agreement terminates, so does the PC's right to use the intellectual property in connection with those types of services. So there'll also be, there'll often be requirements for the PC, if it's going to remain in existence, to change its name, if the name contained the name of, or the intellectual property of the management company. There are also usually restrictions on the ability of the PC and the PC owner to engage in competitive services during and after termination of the management agreement. The management fee is usually structured in a way that will basically make it so that the economics of the transaction are such that it's as though the management company is able to enjoy the economic benefit of operating the practice without actually being involved in the delivery of the healthcare services. So aside from the management agreement, which is kind of the key document in the friendly PC model, you'll also typically see an agreement among the PC owners and the management company where the PC owners agree to certain restrictions on the transfer of their equity and their shares of the PC. And the management company will have some control over how those shares are transferred and handled. But key here is that the voting power of the shares will need to remain with the professional owners of the PC, because you want to avoid any actual control of the PC by the management company. So, even though we set up these friendly PC models to comply with state corporate practice doctrines, there's always still a risk that a regulator or, even potentially a competitor will complain about them. If they're not structured properly, a regulator could argue that the management company really has all the control in the operation of the practice. So to defend against that argument, you want to make sure that you take steps to document that the PC owners are involved and aware of how the business is being operated, that they have sole control over clinical decision-making matters or other matters that relate to the delivery of services by the PC, hiring of the professionals as well.
All right, tax exemption. Section 501c3 provides tax exemption for corporations organized and operate exclusively for charitable, scientific, or educational purposes, so long as no part of the organization's net earnings inure to the benefit of any private shareholder or individual. Of course, tax exemption issues come up when you have tax-exempt hospitals doing joint ventures or other transactions with for-profit physician groups or other for-profit entities. There are several potential adverse consequences tax-exempt entities could suffer from improperly structuring a joint venture with a for-profit partner, including the loss of tax exemption if the tax-exempt entity is not operated primarily for charitable purposes, if there's impermissible private inurement or excess benefit to insiders or third parties. There could also be intermediate sanctions for disqualified persons. And finally, there could be taxable unrelated business income and an adverse impact on tax-exempt bond financing if transactions are not structured the right way. So again, there can be no private benefit or inurement under 501c3. It's important that the exempt organization ensures that all transactions with for-profit entities are fair market value. Compensation paid to for-profit parties should be fair market value. Common compensation arrangements in physician-hospital joint ventures include management service agreements, payer contracting agreements, professional service agreements. In each case, compensation should be consistent with fair market value under the tax exemption rules and for other regulatory reasons we discussed earlier in this webinar. If a tax-exempt entity is contributing assets to a joint venture or to a business, again, it's important that the tax-exempt entity receive credit for the fair market value of those assets. We often recommend bringing a valuation firm to determine fair market value for material assets. Sometimes we engage that firm, again, to protect the attorney-client privilege, so we can be involved in making sure the valuation is done appropriately. In 2002, the IRS emphasized the importance, again, of making sure a tax-exempt joint venture partner is credited with the value of an existing business that's being transferred to avoid giving a for-profit JV partner an undue private benefit. For example, in the ASC joint venture we'll be talking about later today, if a hospital is shutting down its outpatient surgery center, there's a question as to whether the hospital should receive some sort of credit for transferring that business, that service line, to the joint venture. There's a series of cases that also make it crystal clear that the exempt organization has to have formal or informal control over the joint venture with a for-profit partner to ensure furtherance of the charitable purposes of the exempt organization. Now, tax-exempt organizations often worry that the Redlands case and the St. David's case require that the exempt organization control 51% of the joint venture. This is not strictly required by the case law. Although having control of the board is obviously helpful when demonstrated to the IRS that the exempt organization has adequate control to ensure the joint venture will be operated in a manner consistent with the exempt entity's tax-exempt status. Each joint venture is unique, and the parties typically agree upon the amount of control for the tax-exempt organization after very lengthy negotiations. In those situations where the exempt organization does not have a majority of the board, the exempt organization will typically have strong reserve powers, including the power to initiate, not simply veto, actions of the organization, and the joint venture agrees to comply with the exempt organization's policies regarding charity care, for example, the healthcare space. In either situation where the exempt organization has a majority of the board or strong reserve powers, the for-profit partners typically don't like the relatively weak position in which they find themselves, and thus they often negotiate and demand the right to have significant control over clinical and other administrative matters, to approve certain fundamental transactions, mergers, sales, etc., and provide a third-party dispute resolution process when the hospital or the exempt organization insists that certain actions are required for the exempt organization to maintain its tax-exempt status. Often joint ventures do include a buyout or dissolution provision allowing the for-profit partner to be bought out or have the joint venture dissolved if the tax-exempt organization's requirements make it unprofitable, too burdensome, too painful for the for-profit partner to remain in the joint venture. So to summarize, The questions to ask when forming a for-profit joint venture with a tax-exempt organization is, does the joint venture serve a charitable purpose? Does the joint venture bring a new service line or facility to the community? Does the joint venture further a charitable mission of the tax-exempt organization? For example, providing care under the tax-exempt organization of the hospital's charity care policy? Does the tax-exempt organization have adequate formal or informal control to ensure furtherance of the charitable purpose through the majority of the board or the reserve powers, for example? Again, importantly, all financial transactions and arrangements must be consistent with fair market value. Again, is the tax-exempt organization or hospital receiving fair credit for contributed business or assets? Will returns, earnings be distributed based upon the relative ownership interests? Are compensation arrangements set at fair market value? Again, for management services, professional services, leasing arrangements, etc. And consider engaging a third-party appraiser to make sure that, the transactions are fair market value, and consider having a law firm or a lawyer lead that valuation process. All right, now moving on to the joint venture. As we mentioned, we're going to be looking at a hospital-physician ASC joint venture. It's a hybrid joint venture where the physician group and the hospital, the tax-exempt hospital, will have equal ownership of the new joint venture entity. The physician practice will provide management services to the joint venture. The tax-exempt hospital will provide payer contracting services. And with that, we'll look at some of the regulatory issues associated with this type of arrangement.
So whenever you're dealing with a physician group involved in this joint venture, one of the key questions is which physicians will be investing in the joint venture. So this will vary group to group. Some groups have the philosophy that all investments are done as a group, and that if an investment is available to one physician, it should be available to all physicians. Other physician groups may take a different approach and may have only certain physicians involved in the venture. So whatever path you choose, you want to avoid basing investment opportunities and the terms of the investment on the referral potential from the physician. So you want to do this for two main reasons: avoiding any kickback issues, and if the hospital is tax exempt, you don't want to jeopardize the hospital's tax exempt status. So as I mentioned earlier, that I would talk a little bit about the ASC safe harbor. There are several elements to the safe harbor under the anti-kickback statute for hospital and physician-owned ASCs. But one of the key requirements is what's known as the one-third test, the one-third income test and the one-third procedures test. So for single specialty ASCs, at least one-third of each physician investor's medical practice income from all sources for the previous fiscal year or 12-month period must be derived from the physician investor's performance of ASC procedures. If you're dealing with a multi-specialty ASC, you have to meet, or each physician investor must meet the one-third income test, and at least one-third of the ASC procedures performed by each physician investor for the previous fiscal year or 12-month period must be performed at the ASC. Some other elements: the investment must not be related to the volume or value of referrals from the physician. Distributions must be directly proportional to the amount of capital investment of that investor, not referral activity. Also, patients must be fully on board of the physician's ownership. It's also not unusual for states to have similar disclosure laws, so be very aware of what the state law requires from that perspective. Also, no loans or loan guarantees by other investors are allowed under the anti-kickback statute safe harbor. Another key element of the safe harbor is that the hospital investor not be in a position to make referrals to the joint venture. This is a requirement that I don't think I've ever really seen satisfied. But as mentioned earlier, you don't have to meet the safe harbor to still be compliant. If the joint venture doesn't satisfy the safe harbor elements, and it can often be helpful to look at advisory opinions that are issued by the OIG that may examine various ASC arrangements. So the Office of Inspector General will issue advisory opinions where it will opine on various arrangements and their compliance with the anti-kickback statute. In the opinions, the OIG makes it very clear that an advisory opinion is only binding on the party that requests the opinion, but it can still give us a lot of insight into what factors the OIG considers when doing its analysis. So the OIG has issued several opinions that discuss physician investors, and particularly whether they satisfy the 1/3 test. The main concern that the OIG has is whether the ASC is basically a vehicle for rewarding physicians for their referrals. The purpose of the 1/3 test is to safeguard against that because it helps ensure that the physicians are using the ASC as an extension of their practice. So if a physician investor doesn't satisfy the 1/3 test, the OIG would look to see whether the physician's merely a passive investor who's just sending referrals to the physicians who actually perform procedures. In the opinions where the OIG has shot down arrangements, it's been situations where the potential investors have been in a prime position to refer procedures and generally don't provide any sort of procedures such as optometrists and primary care physicians. So the point is, failing to meet a safe harbor doesn't have to kill a deal. It's important to think about whether there's a defensible rationale for the deviation from the safe harbor. Also, to the extent you're going to make exceptions to certain requirements like the 1/3 test, make sure that you do that consistently. Don't just make exceptions for the ones who refer more business to the ASC.
All right, valuation issues. Equity. When structuring this hospital physician group joint venture, can physicians receive credit for the referrals? Can distributions be based upon the volume or value of referrals? The easy answer here is no. Physicians should not receive credit for the referrals. This would raise significant issues under the anti-kickback law. Distributions cannot be based upon the volume or value of referrals. For valuing compensation, including management services, it needs to be both fair market value for fraud and abuse reasons, as well as for the tax exemption requirements we discussed earlier. It's often worth getting independent valuation done to value contributions, especially if any component of the contribution will be in kind. Again, to repeat, it might make sense to have your attorney involved to hire a valuation consultant. You might be able to make the argument that any valuation discussions are covered by the attorney-client work product privilege. For the hospital, to remind you, if the hospital is shutting down an outpatient surgery department and thereby transferring volume essentially to this new joint venture ASC, the IRS has suggested that the hospital should be given some credit for that transfer of business. So regulatory concerns. When setting up these contractual arrangements between the joint venture and the physician group and the hospital, it's very important that the agreements compensate the physician group and the hospital at fair market value. Failure to do so can raise anti-kickback issues, tax exemption issues. Again, consider obtaining an independent valuation. So governance. We talked about the requirements under St. David's and the Redlands case to make sure tax-exempt organizations have sufficient control to ensure furtherance of the tax-exempt organizations, the hospital's tax-exempt purpose. Again, the hospital does not have to have a majority of the board spots to satisfy this requirement, but there have to be both formal and informal control sufficient to allow the hospital to satisfy its obligations as a tax-exempt organization. For antitrust, under this joint venture, the hospital is going to engage in payer contracting. If the hospital will be using its contracts with the joint venture, it will otherwise be competing with the joint venture outside of specified territory or in the territory, it's important to consider the Sherman Act, Section 1, and the Copperwell requirements. Again, the hospital does not have to have control over all matters, but you have to make sure you structure the arrangement to make sure, again, that by a preponderance of the factors, the hospital and the joint venture are a single economic actor incapable of conspiring with itself. All right, buy-sell triggers. There's a very real business issue that comes up in physician-owned ASCs, physician-hospital ASCs, and that issue is where non-productive investors or physicians receive distributions resulting from the hard work of their more productive partners. There's an obvious business reason why many ASCs and investors want to concentrate equity in the hands of the most productive partners to avoid a free rider issue. But ASC should avoid reallocating ownership based upon utilization of the ASC, although for business reasons it might be tempting to do so. Periodic valuations are suspect and disfavored under the federal anti-kickback statute, And as you all know, the consequence of violating this prohibition can be quite serious. So how do you deal with free riders or make sure that the physicians you have as investors are fully engaged? Well, many joint ventures include certain physician investor requirements, and physician investors can be removed for failing to meet these requirements, thereby removing barriers to new investor recruitment or succession. Typical physician investor requirements in the control documents of ASC joint ventures include compliance with the ASC safe harbor, the 1/3 test Katie described, maintaining good standing with state medical boards, maintenance of staff privileges, compliance with various restrictive covenants, non-competes, for example. Any removals without cause from a joint venture need to be carefully reviewed and documented to minimize risk under the anti-kickback statute. I think the lesson here is make sure that you carefully define physician investor requirements, making sure you can remove physician investors for appropriate lawful reasons if you need to do so. But remember, failure to refer is in itself not enough and can raise significant problems for you under the anti-kickback statute. Of course, when redeeming physician investors, fair market value is always the safest course. Removing the physician investors or hospital investors for both anti-kickback reasons, under the tax exemption rules, etc. So that brings us to the bewitching hour, where we get to answer your questions.
Yeah, we have one question asking what sort of issues, requests should be addressed or made during diligence in the acquisition of a medical practice or other covered entity in regard to HIPAA compliance, and what types of HIPAA-type protections, if any, are needed to enable parties to share information during diligence. So this is a good question. So HIPAA compliance has become, much more of a hot-button issue. Usually you're going to want to make sure that you get copies of all their HIPAA policies, make sure they're all up to date, make sure employees are trained on those policies, get copies of their latest security risk analysis that they did, make sure that they did one. With respect to sharing PHI during the course of diligence, so HIPAA does have an exception for the disclosure of protected health information during the diligence procedure of, from one covered entity to another covered entity or to an entity that's going to become a covered entity. So usually that is okay. I mean, caveat of make sure state law also says the same thing or also allows it. You'll still want to be careful, though, about what types of PHI you're providing and make sure that it's really necessary for the diligence review. I'm hesitant to disclose all of your patient lists just, when that's not really necessary to the diligence review. I don't know if we have time for any other questions, but
I think we have just a couple more, maybe okay. Just do one more. So the corporate practice of medicine doctrine seems terribly anti-competitive to me. Is it constitutional? I've heard that some states have found it to be unenforceable. Well, that's a good question. First of all, not all states prohibit the corporate practice of medicine, although most do, and most are enforceable, or should be considered to be enforceable. However, there's a recent case, the North Carolina State Board of Dental Examiners versus the FTC, in which the FTC found that the North Carolina Dental Board violated Section 1 of the Sherman Act, by prohibiting non-dentists from offering teeth whitening services because they were not licensed to do such work. The state medical dental board said, wait a second, we have state immunity. We get to make these decisions, and we're immune under the antitrust laws. And so we can do this. The FTC took the case to the Supreme Court, and the Supreme Court found that there needs to be limits on state action immunity under the antitrust laws, where the state essentially says we're going to delegate our regulatory power to active market participants. Often, in this case, dentists on state dental boards who have a financial interest in excluding competition from the marketplace. The same could apply for physician, medical boards that want to exclude, corporate or other competition from the marketplace. This case, I think, is going to give some state licensing boards pause before enforcing, or in the way in which they enforce some of these corporate practice and similar prohibitions. mean, there have been cases that have followed this FTC decision, the Supreme Court decision. Teladoc brought a case earlier in 2015 arguing that the Texas Medical Board's decision to require physicians to have in-person, face-to-face consultations before prescribing medications violates Section 1 of the Sherman Act as being anti-competitive. Again, the Texas Medical Board said, hey, state immunity, we're protected. The District Court for Texas said, nope, sorry, you're not protected. And they pointed to the North Carolina case, one of the first applications. I think we'll see more cases like this.
Yeah, probably.
And so there's a question as to the scope of what? Enforcement authority for states under the corporate practice prohibition, what can be done, what can't be done. But more to come in that, I'm sure. And with that, we're past our time. Thank you for listening in.
Thank you. Good luck with the Powerball.